Good afternoon, ladies and gentlemen. Thank you very much for joining us on this joint 3B Partners in Costs webinar this afternoon. My name is Mark Sullivan. I'm a member of the 3PB Personal Injury and Clinical Negligence team. I'm going to be giving you a fairly brief presentation on QOCS and some of the more recent case law in the area. And then I'm going to hand over to Dominic Woodhouse from Partners in Costs, who's going to talk to you about some of the recent developments in cost budgeting. Speaking for myself, I'm a bit of a neophyte when it comes to using this technology, so I hope everything goes smoothly. But we do have others standing by in the background to help out if I make any technological errors. The format basically will be, we're going to do two presentations of between 20 and 25 minutes. And then we'll have some time for questions at the end. What we'd ask you to do is to log any questions that you may have in the Q&A chat box, which should appear on the lower right-hand side of your screen. And then we can pick those up and deal with them, time permitting, etc., at the end of the presentation. There is a separate chat box if you have any technological problems or anything that's not working and you need to contact the organizer, Lisa Watts, then again, that will be monitored and you can pick it up. The webinar is being recorded, so you don't need to make detailed notes, and indeed we'll also send out to you after the event handouts to all the people who've registered for this presentation. So without sort of further ado, I'm now going to try and screen share. Hopefully, all being well, you now have copies of the slides in front of you. As I say, the first part of the presentation is to deal specifically with QOCS and some of the recent case law. I'm going to deal fairly briefly with some of the basic stuff because obviously I know most of you will be very familiar with the fundamental principles, but it is worth just reminding ourselves of the underlying rationale for QOCS, as expressed in one of the earlier cases in the area, excuse me, Wagoner and Weekend Travel, in which Lord Justice Voss, as he then was, said the rationale for QOCS that Sir Rupert Jackson expressed came through loud and clear. It was that QOCS was a way of protecting those who suffered injuries from the risk of facing adverse cost orders obtained by insured or well-funded defendants. It was, Sir Rupert thought, far preferable to the previous regime of recoverable success fees under CFAs and recoverable ATE premiums. So, as I say, that it's important to remember the rationale because, unfortunately, the rules themselves are not particularly well drafted. And there are quite a few internal inconsistencies and indeed lacunae. And when the courts have interpreted those or dealt with those issues, they've taken a fairly purposive approach to the rules. So as I say, it is important to remember that. And of course, the issue really was, as I say, it was a quid pro quo for the removal of recoverability of success fees under CFAs, which in a sense doesn't have a great deal to do with cost protection. But more importantly, or more significantly, perhaps also the removal of recoverable ATE premia. And that was perhaps partly because it was felt that in a lot of cases that insurance was extremely expensive, probably of limited value in a lot of cases. In multi-track cases, the premium often ran to tens of thousands of pounds and obviously resulted to a degree in an artificial inflation of costs. So, as I say, QOCS was introduced as part of the Jackson reforms to deal with that particular situation. Excuse me. As far as the scope of the regime is concerned, the starting point is Rule 4413, and the basic proposition is that the QOCS regime applies to any proceedings which include a claim for damages for personal injury or under the Fatal Accident Act 1976 or under the Law Reform Miscellaneous Provisions Act 1934. Effectively, in the latter two cases, they tend to go hand in hand in any fatal accident claim. 4413 specifically excludes applications for pre-action disclosure. But indeed, the question arises as to what extent that extends beyond just simply pre-action disclosure applications. And some of you may be familiar with a recent case in Oxford, Her Honour Judge Melissa Clark QC in Waterfield and Dentality, And she, in that case, came to the conclusion that similarly, any pre-issue application for a group litigation order would also be covered. So it may not be simply limited to the single pre-action disclosure type approach. As far as the transitional provisions are concerned, the rules apply in any situation where the claimant did not have the benefit of what's called a pre-commencement funding arrangement. And pre-commencement is the 1st of April 2013. And essentially what that means in practice is that it applies to any situation where there isn't an old style CFA or a pre-1st of April ATE policy. And if it does apply, that is to say that that the arrangements are not caught by the pre-commencement funding provision, then QOCS applies to the whole claim. So effectively, even if the accident to which proceedings relate predated the 1st of April 2013, the QOCS provisions will apply in those circumstances. The effect of the scheme is again, I'll deal with this relatively briefly. It's set out in 4414. And I think the first thing to bear in mind, of course, is that QOCS does not prevent the making of cost orders against claimants. What it does is it affects the extent to which any such arrangement can be enforced. And so therefore, in terms of the original cost order, the usual provisions in CPR 44.2 will apply, and it is always in the discretion of the court as to what form of and in what sum an order will be made. Say 4414 limits the effect of those orders, though, in accordance with the provisions set out in the QOCS regime. And 4414 sets out the basic circumstances in which a costs order against a claimant may be enforced without permission of the court. And effectively, it is only to the extent of any order for damages or interest in the claimant's favour. So that's the underlying starting point or underlying principle. Orders can only be enforced after proceedings have concluded and costs have been assessed or agreed, and any unenforced element of the costs is not an unsatisfied judgment, which is of some comfort perhaps to claimants who find themselves in the position of having a cost order enforced against them. The specific area of difficulty with 4414, despite the fact that it looks pretty straightforward, relates to what is meant by an order for damages and interest. And that was something that came before the Court of Appeal in the case of Cartwright and Venduct Engineering, which is again the case that I'm sure many of you will be familiar with. And it's about 18 months ago now, so it's not completely new, but its application is perhaps still not fully appreciated. And indeed, it is the source of difficulty and has caught out a number of parties who haven't completely fully appreciated perhaps the impact. The Cartwright itself was a case which had settled by way of a Tomlin order, and the terms of the settlement were set out in a schedule to the Tomlin order. It's of interest in another context as well, which I'll come to, in as much as that there were a number of defendants in that case. But at this stage, all we're concerned with primarily is the relevance or otherwise of the manner of settlement. And what the court said in that case, quite clearly, was that a schedule to a Tomlin order is not an order of the court, and therefore any costs order in favour of the defendant or a defendant cannot be enforced against it under 4414, which is perhaps a slightly surprising result. But the court was absolutely clear that there was no really other interpretation of the rules, and it would require some form of an amendment to change matters. But perhaps of greater significance, or of equal significance anyway, in relation to that particular decision is that there was, although it's obiter to the actual decision itself, in the judgment, the court said that in relation to Part 36 offers, that such acceptance does not require any order from the court, So a settlement in consequence would also be outside the words of Rule 44.14.1. And of course, the reason for that is that if a Part 36 offer is accepted, there's no need to get the permission of the court to do so, even if it's accepted late. I'll come back to that in a moment. But essentially, under Part 36.14, the process is automatic. The claim is stayed, and the sum due must be paid within 14 days unless otherwise agreed. There's no requirement for any further order of the court. I mean, I do know, again, in cases perhaps parties have sought to formalize the arrangement in either with a Tomlin order or indeed with a consent order of some sort or another, but it's unnecessary because Part 36 makes ample provision for what is to happen. And obviously, in the case of Part 36 offers accepted late, the only involvement of the court in those circumstances is that any costs must be determined by the court unless they've been agreed. But an order of the court in relation to the costs would not constitute an order for damages or interest. So the net effect of that is subject to what I'll come to towards the end of the presentation, is that in circumstances where a claimant accepts a Part 36 offer late, and in accordance with Part 36, the defendant is entitled to costs in a cost order in relation to the post Part 36 costs, if I can put it in those terms. There's no ability to recover those costs against the settlement, which is to say maybe a slightly surprising consequence, but in the views of the court was undoubtedly the correct position. So that's definitely something to look out for, obviously, in the context of the provisions of Rule 44.14. I suppose there's one possible way round that, which is that, in fact, under Part 36, if the settlement is not, if the payments aren't made within 14 days, then the claimant has the right to and have judgment entered in his favour or her favour. And I suppose the question arises as to whether or not an order enforcing that judgment would be eligible or available for offset. It's a slightly academic point, I suspect, and I certainly don't know it's never been considered. But personally, I think it's extremely unlikely that the court would allow a party, a defendant in this case, to circumvent QOCS by simply refusing to honour the terms of an agreed settlement. It would seem to be slightly iniquitous, to say the least. So I think, as I say, the chances of that being applicable are probably fairly remote. So going on then from 44.14, which sets out the basic position as far as enforcement of orders is concerned, there are two groups of exceptions to the QOCS regime within the context of the QOCS rules. And the first are set out in, or is set out in Rule 44.15. And this is where the permission of the court is not required in order to enforce the order. And essentially it applies to circumstances where the claim is struck out in accordance with Rule 44.15.1. Now that ought to be relatively straightforward, you might think, but unfortunately life's never that simple. And if one looks, in fact, at Rule 44.15, it sets out specifically the grounds on which the strikeout must occur in order for the exception to QOCS to apply. And what it focuses very much on is the conduct of the claimant, in as much as under 44.15, the three bases on which the strikeout, the effect of strikeout will be to disapply QOCS, is if firstly the claimant has disclosed no reasonable grounds for bringing the proceedings, secondly, the proceedings are an abuse of the court's process, or thirdly, the conduct of the claimant or any person acting on the claimant's behalf and with the claimant's knowledge of such conduct is likely to obstruct the just disposal of the proceedings. Now, in a sense, the problem with that is that if one looks at Part 3.4, subparagraph 1, which is the principal provision in relation to strikeout, the grounds for strikeout under CPR 3.41 relate very clearly, as far as A and B are concerned, to the pleadings. That is to say that the pleadings disclose no reasonable grounds for bringing the claim. Secondly, the statement of cases an abusive process or otherwise like to obstruct just disposal. Or thirdly, the failure to comply with rule, practice, direction, or court order. And the general view, and I don't believe there's any specific authority on the point, but the general view is that any strikeout under 4415, which will have the effect of essentially disapplying QOCS, needs to be a strikeout on grounds A or B of CPR 3.4. So the simple, for example, failure to comply with an unless order or some other such provision, well, I guess an unless order would be, there'd be an automatic strikeout in those circumstances, but the failure to comply with the rule, practice, direction, or court order provision is not enough to get a defendant into the disapplication of the QOCS provisions. And indeed, as I say, in particular, the QOCS provisions focus very much on the conduct of the claimant. It might be argued, for example, that the conduct of the claimant that falls within C, which is to say that it's likely to obstruct the just disposal of the proceedings, would include, shall we say, flagrant breaches of court orders or repeated breaches of court orders, which might justify a strikeout under 3.41C. But as you'll see, there's a further provision required there, which is that the claimant, that it must be the conduct of the claimant or a person acting on his or her behalf, specifically with his or her knowledge. So again, that's an additional hurdle, if you like, that a defendant would have to get over in order to be able to ensure that the QOCS provisions were not applied. And I think the moral of the story basically is that when defendants make these applications, or indeed if claimants are defending these applications, one has to look very carefully at the provisions at 4415(1), and in particular the circumstances in which they will apply, as opposed to, for example, when general strikeout might be available under 3.4. And in particular also, there'll need to be care with the drafting of orders to ensure that the reasons given for the strikeout coincide with 4415(1). And as I say, if on the assumption, obviously, as I say, that the defendant's primary purpose in applying for strikeout is to disapply QOCS. There's another issue as far as that aspect is concerned. I beg your pardon, I've jumped a slide, I think. I beg your pardon. And that is to say, where the claimant discontinues the proceedings before the defendant has had the opportunity to make an application for strikeout. There is obviously provision in Part 38, which to allow a defendant or the recipient of a notice of discontinuance to apply to have it set aside. And I've certainly personally had a number of cases where I've seen an application has been made to set aside a notice of discontinuance, specifically with for the purpose of having the claim then struck out and having the QOCS regime disapplied. There are two, to my knowledge anyway, reported cases where that has happened, or at least there's been an attempt in those of that nature. The first one is the case of Shaw and Medtronic Core Value, which is on the slide. There's another case called Mab and English, which is also a 2017 case. And it has to be said, in both of those cases, the court rejected an application or dismissed an application to set aside a notice of discontinuance, simply in order to allow the defendant to apply for strikeout. Distinguish that, of course, from the situations where you have allegations of fundamental dishonesty. But certainly in the absence of fundamental dishonesty, the courts are extremely reluctant to allow effectively a notice of discontinuance to be set aside purely for the purposes of striking it out in order to achieve a better result in costs for the defendant. So that's obviously something that one needs to bear in mind. And the other question that arises is what happens in relation to other orders that might bring proceedings to an end. I mean, in fact, I actually have a case at the moment involving an application to strike out by a defendant. I'm for the claimant, in fact, in which the defendant is applying to strike out on the basis that they haven't been given effective service. I won't bore you with the details, but the long and the short of it is that it seems to me that's not an application for strikeout. That's an application under CPR Part 11, disputing the court's jurisdiction. And if that application were successful, then in a sense there were no proceedings. So it seems to me arguable that in those circumstances, the QOCS exception in 4415 would not apply. As I say, that's yet to be resolved, but it's certainly something, again, to bear in mind. The second category of exceptions are those where the permission is required. The most important and perhaps most significant of those, obviously, are cases involving fundamental dishonesty. And I'm sorry to disappoint everybody, but I'm not going to say anything about that at all today. There have been countless other, I'm sure, presentations on the subject, and it is a subject in itself, if you like. So, as I say, I'm not going to say anything further about fundamental dishonesty, but I am going to say something about mixed claims. There are two aspects, in a sense. That this is under 4416(2), and this is, this is where permission of the court is required in order to disapply the QOCS protection. There are two types, as I say. The first point to make, of course, is that these will have the effect of allowing the order to be enforced to the full extent of the costs order, but they are also, as I'll come to in a moment, subject to the qualification that it must be just to do so. And again, we'll come back to that in a moment. The two basic circumstances are where a claim, the proceedings include a claim made for the benefit of somebody other than the claimant, and there's a specific carve out there in relation to gratuitous care and subrogated claims for employers and medical insurers. But there's also further guidance in the practice direction, and that would include, for example, claims for credit hire or other subrogated claims. So they fall within, if you like, the claim made for the benefit of somebody other than the claimant. And in those circumstances, if the court finds that is the case, then the order for costs can be enforced against the claimant, and indeed by virtue of 4416(3), it can also be enforced against the person for whose financial benefit the claim is brought. So that's potentially quite a significant carve out, if you like, in the context of the QOCS regime. The second aspect is where a claim is made for the benefit of the claimant other than a claim to which the section applies. And I'm afraid this particular provision has caused quite a lot of consternation and difficulty. There were a series of first instance decisions which considered it. But the final word, in a sense, at least at the present time, is to be found in the relatively recent case of Brown and the Metropolitan Police Commissioner from 2019. Very briefly in that case, the claimant brought a claim against the Met Police under the Data Protection Act, the Human Rights Act, breach of contract, and various other matters. It included a claim for personal injury in the form of psychological distress caused by effectively the unauthorized disclosure of personal information about her and her daughter. But the personal injury aspects of the claim were dismissed. The Data Protection and Human Rights Act claims were admitted, and she got judgment on the misuse of private information claim. And she was awarded damages, but unfortunately unfortunately for her, the damages were less than a Part 36 offer that had been made in the course of the proceedings. And so therefore it fell to the court to consider whether or not the claimant was entitled to QOCS protection in relation to those cost orders made against her that related to the non-PI claims on which she was liable for the costs since the Part 36 offer. And briefly, it's quite a lengthy decision, quite a lengthy judgment, and to a certain extent bears careful reading. But the court effectively rejected what was described as the literal interpretation of the proceedings. There's an obvious dichotomy between what is said in 4416(2)(b), which is that the exception relates to a claim where a claim is made for the benefit of the claimant other than a claim to which the section applies, when under 4413, the section applies to proceedings which include a claim for damages. So in a sense, the section on the basis of 4413, the section applies where there's in any event where there's a claim for damages. for personal injury. So that, and as I say, there was a fundamental problem with that. To cut a long story short, the court effectively opted for what, as I say, a purposive approach, and said the starting point is that QOCS protections only applies to claims for damages for personal injury. It's not limited to damages for pain, suffering, and loss of immunity. It does include any consequential loss, but the damage to property or alternative vehicle hire, and these are just examples that were given, they're not exhaustive, were not consequential, which were not consequential or dependent on the personal injury claim, fall within 4416(2)(b). However, QOCS is not irrelevant, and because at the end of the day, it's a matter of, it's not a matter of discretion. It has to be just to make the order. And if the case is fairly described as a PI case, unless exceptional features of the non-PI element, he would expect the court to achieve a cost-neutral position through the exercise of its discretion. And indeed, there was some wording in the original practice direction which suggests that the normal order in those circumstances was that the claimant would be required to pay the cost. That's now been removed. It is still very much a matter of discretion, and it has to be just. Very briefly, I'm sorry, I'm running out of time, but I'm just going to rush through the last two bits. Multi-party cases. This is a situation where you have multiple defendants, and under 4414, and in light of the decision in Cartwright, which I've already referred to, as a matter of principle, a defendant who has a cost order made in their favor can enforce that order against damages awarded against another defendant. And that was particularly, in that particular case, as I've indicated, the matter was settled by virtue of a Tomlin order. But if it hadn't been, then the defendant who'd been discontinued against would have been able to recover. In fact, there was I know we're going to say deal with questions at the end, but there was a specific question in relation to that, I think from Tamsin Day at Wiseman Lee, about what to do in situations where you've got multiple defendants. I think what the position basically is this, that you will have cost protection in relation to each and every defendant that you issue against, but it's not a license to issue against all and everybody, because if you do end up discontinuing against one but succeeding against another, then there may well be that may well come back to bite you, if you like, at the end of the proceedings, unless of course they're settled by Tomlin order or Part 36 acceptance, which goes back to the point that we were discussing before. The final matter I want to deal with, and again it's going to be rather brief, I'm afraid, is that of set-off, because again, that's a matter that's been the subject of considerable debate. I'm going to summarize it in these terms. The question really is whether or not, even where a defendant is unable to enforce their cost order against the damages for whatever reason, whether they are able nevertheless to offset any cost order against any costs they're liable to pay within the course of the proceedings. And that's based on CPR 4412, which is the general provision in relation to set-off. The short answer to the question is contained in Howe and the MIB, which basically said that yes, you can, and it's a very short case, a very short decision. It's unreserved. It runs to 2 pages, and basically says that set-off is not prevented by 4414, or is not limited by 4414. That case was followed in the case of Faulkner and the Secretary of State for Business, Mr. Justice Turner, in 2020. But it came back before, the issue came back before the Court of Appeal in Ho and Adelaken, which is, and I've given you the reference there. And in fact, in that particular case, the Court of Appeal took a completely different view. It's a much more reasoned, in a sense, much better, much more thoroughly argued case. And the conclusion of the Court of Appeal in that particular case was that if 4414 had intended, or if the intention of the QOCS regime was to allow set-off, it would have said so, and that Section 2 of Part 44, which covers the QOCS regime, is a self-contained system or regime, and no reference is made to 4412. However, the court felt bound by Howe. They were not persuaded that Howe was a decision given per incuriam. However, they have given leave to appeal to the Supreme Court. I have made some inquiries. I'm afraid at the moment that seems to still be pending with no obvious date as to when it's going to be heard. If anybody knows otherwise, I'd be delighted to hear. But as I say, on that rather suspenseful note as to what will the Supreme Court do about Howe and Adelaken, I'm going to finish my presentation there, and I'm going to hand over to Dominic, and I apologize if I've overrun slightly, but bear with me a second as I come out of screen share, and hopefully that will allow Dominic to come onto the screen. So thank you. There will be time for questions, so please bear with us.
Good afternoon, everybody. Hopefully everyone can see the presentation. Just bear with me while I get the alternative screen up. My name is Dominic Woodhouse. I'm from Partners in Costs, and today we're going to take a whirlwind tour through the changes to CPR 3 and Practice Direction 3E. We'll also touch briefly at the end on the topical subject of significant development, exactly what that is. I can see that there are some questions that have been coming through in relation to that, so we'll be able to pick those up at the end. So to begin then, we start by just setting the scene. Fundamentally, prior to the 1st of October 2020, which is when the budgeting rules have changed, we or you have gotten used to the system where you'll be looking at for your resources in relation to where you find the cost budgeting rules. You're looking at part 3 of the CPR, Practice Direction 3E, and for those in the know, there was a guidance note which was appended to Practice Direction 3E. Fundamentally, I do want to get across that the vast majority of the cost budget rules that you've got used to over the last 7 years are still exactly the same, albeit that we might find the actual rules themselves in slightly different places. On that basis, we know that it still covers intrinsically the same types of claims, the same types of values of claims. You still have to serve your documents at the same time in terms of your Precedent H, dependent on the value of the claim, and which is set out on the slide. As I say, I want to race through these to make sure that we can get this in within time. Fundamentally, again, we've still got all the same draconian consequences for failure to properly file and serve complete budgets, so that the spectre of not recovering costs or not recovering budgeted costs is still fundamentally there. So overall, you are very much going to be looking and considering in substance the same rules. What is happening then? So what are we talking about today? Today we're picking up on the amendments that were made to the cost management rules with effect from the 1st of October 2020. First of all, Practice Direction 3E was amended entirely. It changed so much that they've just removed the old Practice Direction and replaced it with a new version. The separate guidance note that I referred to that was appended to Practice Direction 3E has been removed. And so now the only places that you find specific rules in relation to cost management is within Part 3 itself and the Practice Direction to it. Importantly, and it's generated a lot of comment in terms of online commentary, we have the introduction of Precedent T, which will review and will govern the way in which you have to seek to amend or vary your budgets where you can demonstrate that there has been a significant development. So if there has been wholesale revision, if Practice Direction 3E is removed entirely, surely that must mean that there have been very large and substantial changes. For the most part, the answer to that is no. All of the existing requirements, as I say, that you've gotten used to over the last 7 years are largely the same, albeit that you'll find them in different places within the rules. Is there a change of emphasis? Because some, as we say, the Precedent H guidance note itself is removed. The provisions that were contained within it, some have been transferred into the rule, some have been transferred into the practice direction. Is there a change of emphasis on those rules and provisions when they've been transferred over? For the most part, it seems no, that it is a matter of housekeeping. Rationalization of the rules is referred to in the explanatory note. There is a change of emphasis in relation to a few points, not necessarily by the fact of their transfer into different locations within the rules, but rather by a very slight, though no doubt significant, change of wording and therefore emphasis. Importantly, as I've mentioned, we have Precedent T. It's going to be exceptionally important that you do follow the procedures that relate to that, and that we do use Precedent T itself when seeking to vary budgets. So we start then with looking at Practice Direction 3E. As ever, in relation to the rules and as ever in relation to rule changes, I do encourage you to go to the rules, consider them in detail, As ever, no doubt the nuance of rules and potentially the important aspects of them as they bear upon specifically in relation to your case might well only be picked up by close consideration of the rules. Today, I'm just going to look at those important aspects that have fundamentally changed. So I'm not going to cover where you're going to now find different provisions if they've changed. We pick up firstly then in Practice Direction 3E and Section C9. It deals with contingent costs. Fundamentally the same provision, absent the part that's been emboldened on the slide, was included verbatim within the Precedent H guidance note. So the provision itself isn't particularly new. What is new are the words in bold. Costs which are disputed, such as the need for a particular expert, should be set out in the appropriate phase of the budget and if necessary marked as disputed. I believe over the last 7 years or so forth, many parties have had to grapple with that idea of, well, I've got to budget for all the things that might happen in this case, or I believe will happen. I've got an opponent, using this example, that seeks particular medical evidence, which you, as the hypothetically I, as a claimant's representative, don't agree to them obtaining, but nevertheless we need to make provision for it within the budget so that we're not caught out where the court gives permission and it isn't properly catered for within the budget. That would often be included, or those costs would often be included as contingencies. It was much easier to therefore strip those costs out if the court didn't give permission for that relevant evidence. We can't now take that approach following the provisions in Section C9 in Practice Direction 3E, and it will be necessary to still include those costs, notwithstanding that you might dispute that they're actually necessary within that litigation. But if your opponent is indicating that they intend to take that litigation down a particular avenue, notwithstanding you might disagree with that course of action, you will still need to make provision in your budget, and that will still need to be where those costs would naturally fit within the budget by reference to the different phases rather than including it as a contingency. So taking that example of expert evidence which you dispute, it will be necessary to still include that within the expert report phase. Albeit you or your cost adjuster may have to be slightly creative in terms of spelling out how much of those costs are disputed, what they relate to. So it is still easy for the judge on the CMC to strip those costs out if they disagree with giving permission. The other addition to Practice Direction 3E concerns oppressive behaviour. It's dealt with at paragraph 13. Again, this isn't an entirely new provision. It was previously contained right at the very end of the Precedent H guidance note, but it has now been transferred over into the Practice Direction. As I said just a few minutes ago, I'm not convinced that there's necessarily an enormous change of emphasis by changing these things and transferring them from, for instance, the guidance note into the Practice Direction. Nevertheless, it has brought this particular provision to a lot of people's attention that presumably weren't necessarily aware of it before. It's an important one, as per paragraph 13 and appearing on the slide. Any party may apply to the court if it considers that another party is behaving oppressively in seeking to cause the applicant to spend money disproportionately on costs, and the court will grant such relief as may be appropriate. We only have time for relatively short and quick commentary today. I just note at this point that there are only two ways, generally speaking, that you're going to be able to deviate from your budget, if I can put it in that way. One is by showing that there's been a significant development so that you can persuade the court to vary the budget as it stands. The other is to demonstrate a good reason to depart from the budget on detailed assessment when the court comes to assess it. So an additional provision, which, as I say, has been in existence for some time but has often been overlooked, that additional provision enabling a party to ask the court for relief where the opposing party is forcing them to behave in a way which is bound to breach the budget, is bound to be really an important weapon in your arsenal. No doubt it's not something that you want to engage cavalierly. No doubt there will be a hurdle to overcome in persuading the court to use that power. Nonetheless, it's there. It's important that we recognise it and use it when appropriate. That takes us on to amendments to the actual rule itself and part 3. The amendments which have been made to Part 3 are generally to introduce, or most of the points starting at the right place, some introduce new provisions, as we'll see. Generally speaking, though, it's to transfer existing provisions from Practice Direction 3E or the guidance note into the rule. Fundamentally, we can still be quite comfortable that we do know the rules as they currently stand, albeit we're just going to look at some now, which to some extent are new or changed in a material and substantial way. So, new CPR3, the additions which are made are to CPR 3.13 and 3.15. As I've explained, they mostly mirror existing provisions. They don't, for the most part, appear to be any significance in the fact of their transfer in between the guidance note or the practice direction into the rule and so forth. Looking at what specifically has changed, just trying to keep an eye on the time. 3.15a is very significant and very important to us. These provisions as they stand were previously almost, were included in the practice direction almost verbatim, save for one important point. So a party must revise its budgeted costs upwards or downwards if significant developments in the litigation warrant such revisions, and any budgets revised in accordance with paragraph 1 must be submitted promptly by the revising party to the other parties for agreement and subsequently to the court in accordance with paragraphs 3 to 5. Firstly, the important point to pick up is that the word must within those provisions was previously shall. When it appeared in the practice direction itself. Shall, it seems to me, always does connote a definite need to do something. It's certainly been put beyond doubt in the change of that into must. So these are definitely mandatory provisions. There does seem to be a greater emphasis on these in the fact that we've changed shall into must. We've transferred the provision that was previously contained in the guidance note, I believe, or maybe getting confused, perhaps it was in the practice direction, but nevertheless these are transported directly into the rule, and there is that very clear indication that these are mandatory provisions that the court will expect to be complied with. The other important point to pick up from that is the direction of travel in those particular provisions. Firstly, your revised budget must be submitted to your opponent before then submitting it to the court. There was a case in 2018 referenced at the bottom of that slide before Master Yoxall, where he took the view that because the budgeted or revised budget had simply been sent straight to the court asking for variation, they hadn't followed the procedure to submit that to the defendant first. On that basis, Master Yoxall took the view in DYR that the court therefore wasn't actually, didn't have power to vary that budget because the provisions of the rules hadn't been followed. It's really important that we do take notice of this, the way in which that's supposed to operate. It's the same issue really in the sub-paragraphs that continue it. So the following two slides set out really process by which you're supposed to deal with these variations. So as you can see from the slide, picking up at subparagraph 3, the revising party must serve particulars of the variation proposed on every other party using the form prescribed by Practice Direction 3E. That is Precedent T, and we'll take a bird's eye view of that in a moment. Secondly, the revising party must confine the particulars to the additional costs occasioned by the significant development. So just pausing there briefly, there is a very clear indication that it's not carte blanche when it comes to revising your budget to have a second bite of the cherry at any particular aspect you like. The only aspects you'll be able to change, and which the court will consider itself seized of for the purposes of budgeting purposes, are those aspects where you can say there has been a significant development and the impact of those costs or that development is felt in these particular phases. So the only things we'll be able to vary are those upon which the significant development bears. Thirdly, under subparagraph 3, the revising party must certify in the form prescribed by Practice Direction 3E that the additional costs are not included in any previous budgeted costs or variation. We find that certification, again, it's spelt out in Practice Direction 3E. It's also automatically included in the version of Precedent T, which appears on the Court Service website. As ever, it's better to stick with the published versions of these precedents. There's always some danger in cobbling together your own, so I do encourage you to go to the precedent itself. We then move on to the further subparagraphs. Again, we're talking about the procedure and effectively the direction of travel that we have to follow. Subparagraph 4, the revising party must submit particulars of variation promptly to the court, together with the last approved or agreed budget and with an explanation of the points of difference if they have not been agreed. As we'll see when you look at Precedent T, Precedent T will require you to set out the variation you seek. It will require your opponent to endorse within that document their reasons for either agreeing or disagreeing or opposing the variation you seek. There's no space within it for you to explain those points of difference, and certainly no provision within it for you to put in any counter arguments. It may be, especially as it appears that what's contemplated in these rules is potentially for the court to deal with quite a number of them simply on the papers rather than hearing oral arguments. You may find that you do need to, when submitting the Precedent T to the court, which confirms the defendant's thinking or your opponent's, you might find it necessary to explain further within the letter submitting it, copying it to your opponent, as to why you disagree with their disagreement, if you follow that thought. At subparagraph 5, the court may approve, vary, or disallow the proposed variations, having regard to any significant developments which have occurred since the date when the previous budget was approved or agreed, or may list a further cost management hearing. Again, just picking up on that point, at the first instance, the court may well be dealing with these applications on the papers alone without oral argument. So it'll be very important that you do put your best foot forward. We then move on to subparagraph 6, where the court makes an order for variation. It may vary the budget for costs related to that variation, which have been incurred prior to the order for variation, but after the cost management order. Again, another very clear indication of how confined and restricted the court's powers are, simply in relation to the subject matter of that significant development. It's not a wider free-for-all to try and bring in other issues. It also importantly picks up that point which we first saw on an authoritative basis in Sharp against Maurice Victor Blanc and others, which was in the High Court in 2017. Effectively, the court makes an order. Let's give a very quick hypothetical example. The court makes an order for cost management in March 2019. The parties recognise that there's a significant development and make an application to vary that budget in March 2020. It gets listed for a hearing in, let's say, June 2020. Between the time that the application was made, or more to the point, at the time the application was made, no doubt whatever the significant development is has already started generating some costs. Further costs will have already been incurred in relation to that significant development between the time of making the application and then having it determined at a hearing in court. The question which was posed in and resolved in Sharp and Blanc was whether the court could actually control and budget those costs which had been incurred before the application was actually determined, but after the court made its original cost management order. Sharp and Blanc confirmed that yes, it does. The court is seized of control of costs from the date that it originally makes that cost management order, and that power is now spelt out, or the restriction and limitation on that power is now spelt out at 3.15a6. We then have an addition to CPR 3.17. Again, I apologize because this is a bit of a whirlwind tour. The addition to CPR 3.17 at 3, that the court may not approve costs incurred before the date of any cost management hearing, but may record its comments on those costs and take them into account when considering future budgeted costs. Again, these are existing provisions that we are familiar with, previously incorporated into the practice direction, now transitioned into the rule. I flag it up here because of its apparent or slight contradiction with the provision that we've just looked at 3.15a6. Again, taken together, they do make matters clear. The court can't assess costs or approve them if they've been incurred before the date of the cost management hearing. Once that takes place and the court makes cost management order, it is then seized of the costs that you incur after that time. That takes on to the further subparagraph at 4. Again, it's a provision in relation to interim applications, which is substantially the same as it was in Practice Direction 3E. If an interim application is made but is not included in a budget, the court may, if it considers it reasonable not to have included the application in the budget, treat the costs of such interim applications as additional to the approved budgets. Substantially the same wording as was appeared in the Practice Direction. The change is the previous incarnation referred to interim applications which reasonably weren't included in the budget. The amended wording now provides basically for the court to determine whether or not it was reasonable to. I think that was always implicit in the previous incarnation of the rule, but again, it puts it beyond doubt here. The only other point to pick up on that is, again, if you anticipate that there's potential for you to make an application at the time that you're preparing your budget, then the costs in relation to the application should be included in your budget, because otherwise, later down the line, if the court takes the view that it was unreasonable for you not to include those costs in the budget, then they will not agree effectively to those standing outside of them. So you have to be really cautious in relation to the cost of interim applications, which you do anticipate will happen. That takes us then on to Precedent T. Per Practice Direction 3E, at 3B, Precedent T is confirmed to be the document that you have to use where you're seeking variation of a cost budget. We've got some slides here so we can just see how it looks. Again, I'd encourage you to go to the Court Service website, look at the Precedent T as it appears within there. I've screenshotted each page, but we don't have much time to dig into them. The format of it will be very familiar to you. It's substantially based on Precedent H and the budget document you've got used to over the last 7 years. You can see if we have columns 1 to 6, the first 3 effectively replicate your existing approved budget. It's important to recognize that column 2, starting from the left, referring to incurred costs, that's a reference to the incurred costs as they stood at the time that your budget was approved, and effectively as they stood and were represented in the budget that you originally submitted to the court. So we don't update those incurred costs as to however much they are at the time that you're making that application. The incurred costs in that form stay just the same as they were in your original budget. The third column shows what the court then approved. The fourth column details the variation that you're seeking, whether that be up or down. The fifth column will then show the total amount of that varied budget. So your original approved budget plus or minus the variation. And you have a final column at the end for the court to deal with. I mentioned before that there was a different or new certification in relation to this type or in relation to the Precedent T, and you can see that that is, I certify that the costs and disbursements included in this variation are not included in any previous budgeted costs or variation, including any contingency, whether agreed or approved by the court. Again, it's not a second bite at the cherry. This is confined solely to variation of the budget, which is consequent on a specific significant development. I flag up just as a point of interest that this is certainly the certification that has to be used in the Precedent T, and therefore it must always be used. It does occur to me, though, that the specific form of wording used doesn't sit very well if you're seeking to reduce your budget, because, of course, if you're removing things from it, then, of course, they were in the previous budget. Nevertheless, it's the form of wording that has to be used, and therefore it must be. But I wonder whether there will be some amendment to that at some point in the future. The second page then gives us more information or more space to provide further information, and I'm rapidly running out of time, so we'll fly through these. The only point to note in relation to that for today's purpose is there's a relatively limited amount of space for you to make information available to your opponent and to the court in order to justify the variation that you're seeking. We do suggest that you make best use of that as possible. Remembering always that brief and concise is probably going to serve you better with a very busy judge. The fifth column on that sheet, starting from the left, refers to the specific details of variation. In the box which starts in yellow in that fourth column, approximately 2/5 of the way down the page, it states explanation of particular phase, and in brackets where variation is say phase exceeds £10,000, complete XX. The suggestion within the template is that those individual boxes in column 4 only need to be completed if the variation in the budget that you're seeking is £10,000. From my perspective as a draftsman, I believe that people will generally be better served if they always make use of that space and provide as much information as you can briefly and concisely in the space available. And that will better serve your objectives in seeking to explain that variation to the court. The further page is a summary sheet in relation to disbursement. So again, there's an opportunity to provide a little bit more granular detail in relation to expert fees. You'll be familiar with that from the existing expert fees page within the Precedent H itself. We are rapidly running out of time. The final part of this just concerns significant development. I say just concerns because, of course, it is a very hot topic. It's a difficult topic as well. As per CPR 3.15a, we know that we must seek to vary if there's been a significant development. We must seek to vary either upwards or downwards where circumstances require. Questions have come in and not wanting to preempt those questions, but it is similar in some ways. I don't know how many people might be familiar with the underappreciated Bruce Willis film Hudson Hawk. There's a scene where a chap in a room with the famous picture of bulldogs playing pool behind him says, "I don't know art, but I know what I like." And fundamentally, I'm going to go over some slides which give you general broad guidance in relation to what might be a significant development. It is effectively very difficult to pin that down on a case-by-case basis without looking at the specifics of your case, because again, it is more of a case of you'll know it when you see it to some extent. So the further slides give us some direction. We take direction from Ahoud al-Najjar against the Cumberland Hotel, flying through these now at breakneck speed. Whether a development was significant was a question of fact, which depended primarily on the scale and complexity of what had occurred. If what had occurred was something that should reasonably have been anticipated, then that party will probably be unable to label it as significant or, for that matter, a development. Fundamentally, mistakes and oversights are distinctly unlikely to help us. Further points of principle that can be distilled: that there is no requirement that the development must have occurred other than in the normal course of the litigation. It's not necessary for this to be something so exceptional that no one's ever seen it before. Words of encouragement from the judge in Ahoud al-Najjar. As a matter of policy, the bar for what constituted a significant development should not be set too high, because otherwise parties preparing a budget would effectively throw in the kitchen sink and make those budgets far too generous. It's the other side of that coin, because to some extent al-Najjar is a very helpful case to us, but on the other side of that coin is the need for the court to maintain budgets to a certain extent and not always be granting applications for variation, because otherwise the cost budgeting regime will lose its teeth. It makes the point that if there has been significant development, then the remaining question is whether the figures are reasonable. That takes us on to Edward Michael Seekings to make the point that within that very briefly, which is in considering the significant development, you start with your budget. You look at that significant development in the context of the case that the court was contemplating at the time and which it budgeted. Very briefly, there are indications in the White Book that assist us and help us, and I refer to that there is flagged up in Michael Seekings against Alan Moores. A development is taken into account impliedly if it is something that was or should reasonably have been anticipated by the applicant for revision. Again, we must make sure that we take into account all relevant considerations and everything that is likely to happen within that budget at the time it's originally prepared. There's a slide on the screen. I say no more than to flag up that it highlights in sharp that a mistake again will effectively not be a good reason to depart from that budget, or for there to be a variation of it consequent on significant development, because it should have been appreciated at the time. So to make sure, and in conclusion, make sure you get the budget right, that you make appropriate allowance for everything that should reasonably be anticipated, and that you then do monitor the spend and how much you're spending and developments in the case against the nature and amount of the budget as it was originally set. That concludes my part of this webinar. Very grateful for your attention. Hope we've not prattled on too long. We can now address questions that you have.
Thank you very much, Dominic. Hopefully, I realize we're at 3 o'clock, but I mean, if people want to leave, obviously, then please do. But if anybody will, I mean, I'm happy to carry on just another 5-10 minutes or so, just deal with questions. So if that's okay, that's what we'll do. I think maybe to give Dominic an opportunity to read the questions that have come in while he's been speaking, and there have been a few come in. Perhaps if I just deal initially with the ones that relate specifically to my presentation, and then obviously, Dominic, if you want to take over and deal with the ones that relate specifically to your area of expertise. As far as my piece is concerned, there's a question from anonymous. Does 4415(1)(c) encompass fundamental dishonesty in the C's prosecution of his or her claim? That is to say, in effect, does 4415(c), which covers the conduct of the claimant or person acting on his behalf or with his knowledge, such as it's like to obstruct the just disposal of the proceedings, justify strikeout? I think the logical answer to that question is, well, yes, it must. But as a practical matter, I'm not sure it makes a great deal of difference, because you'd still have to prove fundamental dishonesty in that case, if that's the basis on which you're alleging misconduct, if you like. I suppose, technically speaking, the fact that that can be done, that the order takes effect without permission of the court, as opposed to in fundamental dishonesty where you need the permission of the court, again, it's probably an academic distinction, frankly, because it's hard to imagine circumstances where someone's been found to be fundamentally dishonest, but that the court doesn't remove QOCS protection. And in any event, there's no requirement for it to be just in the fundamental dishonesty situation. So I think the answer to the question is, well, technically it may, but I'm not sure that it would make a great deal of difference from a practical point of view. The second question for me was, is it correct, this is from Andrew Wesson, is it correct that it is not possible to recover costs out of the damages contained in the schedule to the Tomlin order? The answer to that question is, yes, it is correct, as we that's the Cartwright case, and it's pretty clear cut, subject to any amendment to the rules. So I think the answer to that question is relatively straightforward. There's a question on interest on Part 36 costs. I'm going to duck that completely because I don't know the answer. I don't know whether Dominic does or not, but we may get back to that. The next question for me is an anonymous attendee. Does QOCS apply to defendants bringing a counterclaim for personal injury and losses? That's a very interesting question. It was a subject I was sort of thinking about covering, but decided it was probably a bit too complicated, frankly. But the position actually is this, that there is no clear authority on the point one way or the other. There's no Court of Appeal decision. There are two first instance decisions. There's a case called Ketchen and McEwen, which basically said that the defendant benefited from QOCS in relation to his counterclaim or her counterclaim to the extent of the full cost of the proceedings, which seems a slightly surprising conclusion. In fact, subsequent to that, there's a case of Waring and McDonnell, which is a circuit court decision in the county court. Sorry, Waring and McDonnell, which basically said that you treat it, yes, the defendant is entitled to QOCS protection to the extent that he's an unsuccessful claimant. So basically, he's entitled to QOCS protection in relation to his failed counterclaim, but he's not entitled to QOCS protection in the context of being an unsuccessful defendant. And that seems to be a logical approach, although obviously from practical purposes, there may be some difficulty in actually working out the figures, but that does seem to me to be the correct way to approach it. And I think that is all that I had in relation to QOCS. So I think the rest probably are questions for Dominic, but if anybody else has got anything, then please, type it in. Are you in a position to deal with the ones that have been directed to you?
Yes, absolutely. I can rattle through those now. So just picking up from the top at 216, for a precedent T, which circumstances stand a greater chance of being recognised as significant developments by the court and which less so? It's so difficult to say without actually considering it on a case-by-case basis. And I think that's what we have to take away from the cases that have been cited. If you go on to, such as, I appreciate other search engines are available, if you go into Lawtel and search for cost budgets and significant developments, you'll see various cases which you can actually say, well, in this situation, the court was persuaded that an increase in documents for disclosure was something which should justify varying the budget. There are other cases where they've said, no, it's not, because in the specific context of that case, it wasn't held to be a significant development. You've got the same types of examples on issues like the value of the case. Churchill and Booth is a good example where the court was unpersuaded that a substantial change in the value of the claim was necessarily such as to warrant variation of the budget, and decided it didn't in that particular case amount to a significant development. So unfortunately, it does very much have to be rooted in the specific case that you're dealing with and the budget which was set for it originally. The next point in time, if a Part 36 offer is accepted by notice without a court order, when does interest on costs commence? Assuming that the Part 36 offer was accepted within the relevant period, ordinarily the 21 days, but in any event, if it's accepted within the relevant period, then there is a deemed cost order under Part 44, and therefore your interest runs from the date of acceptance, which is the date on which the deemed cost order is created. Again, though, that's very, very much and only on the basis that it's accepted within the relevant period. If it falls outside that time, then there is no deemed order and interest wouldn't have yet run, and you would still need to obtain a court order, usually by consent where it's accepted out of time, in order to enable you to have an authority to get your costs assessed. Next question at 233, with regard to CPR 3, does that mean that budgeting will now apply to children's cases if they have mental capacity? No, the same provisions apply as before. Minor claims are excluded from cost budgeting, and that exclusion continues after they've attained majority unless the court orders otherwise. So again, that's one of the rules. It's in a slightly different place, but it's still the same. So just flicking through, so then at 237, I've just had a case which is going to a split trial, and we did a budget for liability costs only. In the future, would this not be possible? No, the court still has the same powers it did before, which provide that in an appropriate case, the court can decide to budget part only of the case before potentially then going on to budget the rest of it later. So the court still has the power to budget liability only in the first instance, if that's the avenue it chooses to go down. A question at 240. Is this the current phase to record the additional work on the basis of any final factual investigations, pre-trial liaison with witnesses? The question itself doesn't specify the phase that's being suggested, but I believe the wording you're taking it from is trial preparation. The guidance note, which used to set out a table of where particular types of costs should go, that's fallen away, but the same notes now appear in Practice Direction 3E, and final factual investigations and pre-trial liaison with witnesses are referenced as being included in the trial preparation phase. We've then got a question at 249 on a partial approved budget. What is the position regarding the Precedent T? Will this apply just to the approved phases? Do we still file a Precedent H for the unbudgeted phases, or do a combination of the two? Rules do not appear to give guidance on this. I agree with that. So on the assumption that, for instance, you go to your first cost budgeting hearing, the court decides that it will give directions for and budget up until exchange of expert evidence, but it's not going to give any directions for work after that or budget those remaining phases. In that situation, it's my belief that yes, if you want to amend or vary your existing budget because there's been a significant development, then you'd have to do a Precedent T in relation to those aspects of the budget which had already been set. You'd then also have to do a revised Precedent H to cater for those phases which have not already been budgeted. 251, and please do feel free, anyone, to stop me if we've lost everyone on the call, or you want us to stop these questions. But 251, does 3.17 apply to applications it refused at the original cost management hearing but are later required? I would assume so. On the basis, I assume that the point that we're making is that you include applications or provision for applications within your budget when you originally submitted it. And the court says, no, you're not. I don't believe you will need to make that application, and therefore remove costs relevant to it from the budget. If that happens, you would assume that you'd have good arguments to say, therefore, these fundamentally must be costs that stand outside the budget, and the court can use its powers under 3.17 to hive those off and have them separate. As with anything, though, and I appreciate that everyone on the call will be lawyers and will be well used to caveating your advice to clients that you have to see papers and things. Again, it's one of those issues which might stand the need to very much consider the specific circumstance on your case. Um, 250 as to whether there's any judicial guidance as to what is meant by promptly in terms of submitting particulars of variation. No, again, I think it's a term of art. What is promptly will probably be case sensitive on any particular case, and it's the same way as they are in relation to applications for relief from sanction, and that whether there's been delay in making that application. So no, not as far as I'm aware. And does the £10,000 limit apply to each phase or overall? It's not at all clear really from the Precedent T, where within Precedent T it suggests that you should only fill in those extra details if the variation is more than £10,000. It's not clear whether that's a reference to the overall budget being increased by £10,000 or per phase. Again, though, I just encourage people to use those boxes in any event. There's no specification in the rules as to the specific information that's to be provided, other than what we've rehearsed during those or through those slides. And I would tend to make best use of the available space as you can. I have a feeling that might be about all of the budget related questions. Sorry, there is one at 3 o'clock. In a budget, how do you deal with differing views as to trial length? Always use the highest. I'd say yes. If it's your client that is seeking the highest trial length, then of course you'd want to include that anyway. If it's the opponent that's seeking a longer trial length than you are, as per the amendments and those emboldened parts in relation to the contingency, then you will want to, I imagine, or be best advised to use their longer trial length, but specify in your assumptions the fact that you disagree with that and how much of your proposed budgeted costs relate to those additional days that can be stripped out if possible.
Dominic, thanks very much. I don't obviously we don't want to sort of cut anybody short, but I'm slightly conscious of the time. What I suggest is that if there are other questions which either of us feel we can answer, then we can do that after the event, either by sending an email to the questioner or I think Lisa has some mechanism whereby we can answer the question after the webinar is finished. I think on that basis, thank you very much to everybody who's attended today. It's much appreciated. I hope you have found it useful. And thank you very much to Lisa Watts and David Snook for setting the thing up in the first place. As I indicated earlier, there will be, you will receive a copy of the handouts or the slides basically. And as I say, should any of you feel the need to listen to it again, which I think is unlikely, but there we go, it has been recorded. So, or if, alternatively, if you have other colleagues who may have wished to attend but couldn't, as I say, that will be available. But as I say, I think other than that, it just remains me to say thank you all very much indeed. Thank you to Dominic, and hope we all meet in person at some point in the not too distant future. But thank you very much indeed.
Thank you, everyone.